Okay, I've started the recording, so let's get started. We have quite a long session, a long unit to finish today. We are busy with Unit 8. We've learned so far that a company has got two organs: shareholders in general meeting, the way shareholders make decisions, and then the directors, the board of directors, acting as a collective, as a board. In Unit 8, we look specifically at the shareholders in general meetings. How are meetings conducted? How do shareholders make decisions at or that can influence the company? Thumbs up quickly if you can see the slides. Okay. Right, so we started with Unit 8 on Tuesday. What we looked at on Tuesday is we saw that there are two types of meetings that a company can have: general meetings that include all the shareholders, and class meetings that affect only a particular class of shareholders. The manner in which these meetings are conducted are exactly the same, so it doesn't matter. Then we looked at the AGM, the annual general meeting, and we did an exercise. We looked at when must annual general meetings be held, and I gave you an example where we actually calculated it. At the end of the day, we were all comfortable. So that is about the AGM. The rest of the unit, we talk about meetings in general meetings in general. Now, the manner in which shareholders make decisions. I'm going to do this. Put in another slide here, because I see this is missing. Shareholders make decisions by way of valid resolutions adopted at valid meetings. That's the bottom line. How do shareholders make a decision? By way of adopting a resolution at a meeting. So a resolution, a fancy term for a shareholder's decision, or a fancy term for a decision. It's not only shareholders that take resolutions, the board of directors can also adopt resolutions. Resolution, a fancy term for a formal decision. Now, the important part is that for this decision, this resolution, to be binding on the company, it must be valid. And in order for a resolution to be valid, there are 3 steps. Firstly, the meeting must be properly convened. Secondly, the meeting must be duly constituted. And thirdly, the meeting must be properly conducted. And these 3 steps fall in a particular sequence. You cannot conduct the meeting before it has been convened. Properly convened looks at the meeting must be called, the invitation to the meeting must be sent out by persons that are authorized to do so. Meeting must be called by persons that are authorized to do so. The correct notice for the correct time period must be sent to all people that are entitled to attend this meeting. Then, on the day of the meeting, before the meeting starts, you need to check, has the meeting been duly constituted? Two aspects that you look at there. Is there a chairperson, the correct person? And more importantly, there must be a quorum. If there's not a quorum, the meeting is not duly constituted. It cannot proceed. A meeting that has not been properly convened and duly constituted cannot adopt valid resolutions. And then once the meeting has started, the meeting must be properly conducted. Voting must take place in the correct manner, and the prescribed majority must vote in favor of the resolution. So you will understand, looking at these three aspects, that they follow a sequence. You don't vote before you've sent out the notice. This is important because if you get a case study where you are requested to determine whether a resolution has been properly, validly adopted, you look at everything that happened in this sequence. If you first tell me, oh, but enough people voted, and then there at the end you say, but they didn't give sufficient notice, you're going to lose marks. Because notice happens first. Then you check if there's a quorum, then you check that the correct number of people vote for this resolution. Don't do it in the sequence, it's wrong. So let's look at the first one. The meeting must be properly convened. Aspects there, who may give notice, what are the required notice periods, and how must the notice be given? So who may give notice of a meeting? Firstly, the board of directors, not an individual director. The managing director acting on his own sends out an invitation to a notice, it's invalid. The directors acting as a board. Then the Companies Act, in the event that a specific member or a specific shareholder feels that there is something that needs to be discussed, something that needs to be decided on. Their first step will obviously be to contact the board of directors and request them to convene a meeting. But if they don't, if the board of directors doesn't do this, the Companies Act in Section 188 and Section 189 provides for two procedures that shareholders can follow in order to convene meetings. Otherwise, the Registrar of Companies also has the right to convene meetings, and the High Court can also order that a meeting be convened. Let's look at Section 188 and Section 189. Now, remember, I told you on Tuesday already that you do not have to memorize the details discussed in the different sections of the Act in Unit 8. In your test, I will be giving you a handout that contains these sections. So you don't have to remember, you have to apply. So section 188. I've put them in a tabular form like this so that you can also compare the two. Section 188 provides that a meeting may be called by two or more shareholders who together hold at least 10% of the issued share capital of the company. Two or more members holding at least 10% of the issued share capital of the company. Section 188 also contains the provision which reads as follows. It says, save insofar as otherwise provided in the articles of the company. Fancy legal terms or legal words, which basically means that the company can, if it wants to, change the provisions of Section 188. Company can, in its articles, provide that in order to call a meeting, for example, you need at least 5 members who have at least 50% of the issued share capital, or whatever they want. And whatever is stated in the articles is what has to be followed. If in a case study I don't tell you that it's been changed, you'd go according to the statutory requirements of Section 188. 2 or more members who hold at least 10% of the issued share capital. I will always, if I give you a case study based on general meetings, I will give you the necessary information for you to be able to check whether the requirements have been met. I will tell you what the issued share capital is, or the value. I'll tell you what the value of the issued share capital is. I will tell you what the value of the share capital held by the individuals in the case study is. You need to calculate these two people that are calling the meeting. Do they have at least 10% of the issued share capital? You are permitted to bring your calculators into the test and the exam. I will be shocked if, in fact, accounting students need a calculator to check whether these people have 10% of the total. I'm also not going to explain to you how you calculate 10% of the total. You've all passed, what is the maths module that the accountants do? Quantitative methods. All passed that, able to calculate 10%. Section 189, firstly, cannot be changed. The actual Section 189 is not subject to the provisions of the articles of the company. If the company is in Section 188, made it almost impossible for members to call a meeting, they can also always fall back to Section 189. Section 189 cannot be changed. It is always applicable. Section 189 provides that a member or members, so at least one member, who holds at least 5% of the capital that carries voting rights. So not of the issued share capital, of the capital that carries voting rights. So in this instance, if there's any question or any reference in the case study to preference shares, you will have to make a decision as to whether these preference shares under the particular circumstances carry voting rights. Preference shareholders do not have a general voting right. They may only vote if their dividends are in arrears or if the decision directly affects their class rights. You will definitely, in your first test, somewhere in a question, have something that relates to section 188 and 189. You're going to have the handout in front of you that contains these details. For goodness sake, look at the correct section of the Act. If I'm asking you, may Johnny and Paul call a meeting in terms of section 189, don't look at the requirements of section 188. You don't need to remember 10%, 5%, blah, 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 blah. You're going to have this in front of you. You need to be able to calculate 10%. You need to be able to calculate 5%. To avoid further confusion, the Act does not really refer to 10%. It refers to it doesn't refer to 5%, it refers to 1/20th. And shockingly so, I've discovered that accounting students do not know what a 20th is. A 20th is 5%. So, in order, if shareholders want to call a meeting, they have to act either in terms of section 188 or section 189. But they can only validly act in terms of section 188 or section 189 if they meet these requirements. If they do not meet these requirements, the notice of the meeting, the invitation sent out for shareholders to come to this meeting, is invalid, which means the meeting will not be properly convened. Questions? No questions. Let's move on. Then the notice must be given at the appropriate time. There must be enough time between the date that the invitation to the meeting was sent and the actual day of the meeting. In terms of the Companies Act, the following notice periods apply. For any general meeting, the notice period is 14 clear days. For the annual general meeting, it is 21 clear days. If the purpose of the meeting is to adopt a special resolution, we're going to get to special resolutions later this evening. The purpose of the meeting is to adopt a special resolution. You need 21 clear days. And then the Companies Act also provides for something called special notice. Don't confuse special notice with a special resolution. These are two different concepts. Special notice is used only, exclusively, if the purpose of the meeting is the removal of directors or the removal of the company auditors. Then special notice is required, which is 28 days. Otherwise, if it's a special resolution, 21 clear days, annual general meeting, 21 clear days, general meetings, 14 clear days. How do you calculate clear days? Don't have a slide for this. I'm going to put it here. How do you calculate clear days? So, just give me a second. You count you clear days does not include the day the notice is sent or the day of the meeting. It includes Saturdays and Sundays, but excludes public holidays. Don't worry about the fact that it excludes public holidays. My purpose behind this is not to test your knowledge of Namibian public holidays. So I will never give you, if you have to calculate, check whether a meeting has been properly sent. I will never give you an example that includes a public holiday and try to catch you out like, ha, 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 you got it wrong because the 26th of August is a public holiday. That's not my intention. So don't stress about public holidays in this regard. Just going to give you do an example with you here. So let's say if the invitation is sent on the 1st of September, general meeting to adopt a special resolution. What is the earliest date that the meeting can be held? Oh dear, what have I just done? Didn't mean to do that. What is the earliest date that this meeting can be held? So for a special resolution, we required 21 clear days. So you don't count the 1st. So you start counting on the 2nd. And then you count 21. Use your fingers. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22. So it's 22. So the earliest date will be the 23rd of September. Did you see what I did there? Did you follow what I did? You don't count the day that the invitation is sent. So you start counting the next day. Then you count the required number of days, and then the day after is the earliest that the meeting can be held. In practice, companies never send out meetings or notices to meetings at such precise dates. If they have to give 21 days notice, they'll probably give a month's notice or something like that, just to make sure that there's no confusion about the dates. Thumbs up if you're still with me. Okay, thank you, sorry. Hilma, great. Okay, lovely. So for the meeting to be properly convened, you need to check that it was given, that the notice was sent by the correct persons, so either the board of directors or a member or members meeting the requirements of section 188 or section 189. You have to check that the correct notice period was given, that there are enough days. And then how must the notice be given? Meetings for notices must be given in writing. Don't have a slide about that. That's easy to remember. But if I tell you that the secretary telephoned the members, their notice was not properly given. Notice must always be in writing. Now, the date of the meeting has arrived. It was properly convened. Now the people are there. Now we need to check. Has it been duly constituted? Not going to, I don't have a slide addressing the issue of the chairperson. Whoever gets to chair these meetings is normally determined in the articles. Who will be the chair or how will the chairperson be selected or whatever. Two aspects that we have to look at with regard to meetings duly constituted is the concept of a quorum and the concept of a proxy. What is a quorum? The definition of a quorum, this is not unique to company law. All meetings have quorum requirements. The quorum at a meeting is the minimum number of shareholders that must be present at the start of the meeting in order for the meeting to proceed. If there are not enough people, the meeting cannot continue. So quorum, the minimum number of members that must be present at the start of the meeting in order for the meeting to proceed. What does the Companies Act say about quorums? The quorum for a public company, 3 members who are entitled to vote, who must be physically, personally present. For a private company, 2 members entitled to vote who must be present in person or by proxy. Going to get to proxy shortly. And then right at the end of this unit, we look at special resolutions. There are also special proxy quorum requirements for a special resolution. So we're going to get back to that. If it's another meeting, there's no special resolution. Public company, 3 shareholders personally present. Private company, 2 members who are entitled to vote who must be present in person or by proxy. This is why this distinction between public companies and private companies, where when we were doing types of companies, I warned you to always be on the lookout, be alert, be aware of what type of company you are dealing with. Look at the name of the company. Is it a limited or is it a Pty limited? because amongst other things, the type of company is going to make a difference to your answer, your conclusion as to whether there was a quorum or not. So what is a proxy? What is a proxy? A proxy is a person who has been given the authority to represent a member of the company and vote on their behalf. So if Hilma, Julius, Rana, and Alicia are the shareholders of the company, and there's a general meeting, but Alicia has got something else on. However, she doesn't want to be marked absent. She still wants her opinion heard. She wants her vote to count. She can give a proxy to Rana. And then if she's given her proxy to Rana, it is her vote. Well, in certain circumstances, we'll get to that, but it is as if she is physically present. The Companies Act, and this is in the notes, so I just want to, it's not on the slide, but I just want to alert you to this because I've picked up confusion about this. The Companies Act says, when it speaks about proxies, it says that the proxy need not be a member of the company. So the proxy doesn't have to be another shareholder. It can be an outsider. If our shareholders are Hilma, Julius, Rana, and Alicia can't go to the meeting, she may give a proxy to Julia to go on her behalf, even if Julia is not a shareholder. Some people read this as the act says the proxy need not be, doesn't have to be. I've picked up sometimes students interpreting this as they may not be. That's absolute nonsense. They may be. In fact, in practice, it hardly ever happens that a shareholder gives a proxy to an outsider. Why would Alicia give a proxy to Julia and expect of Julia to give up her entire afternoon to attend a meeting for a company that she's got diddly squat to do with? It makes more sense for her to give her proxy to Rana, who is a shareholder and is going to the meeting in any event. So just be careful there to not twist the words of the Companies Act. We're going to speak about proxies further during the course of this lecture. Just understand for now what a proxy is. Proxy is like an agent, a person who's been given the authority, except we don't use the word agent in meetings, we use the word proxy. Okay, so now we've checked. There's a chairperson, there's a quorum, and we know who's given proxies or who hasn't given proxies. Now the meeting starts. The meeting must be properly conducted. Voting must take place in the correct manner, and the prescribed majority of people must vote in favor of the resolution. Let's look at these aspects. First of all, to assess whether voting has taken place in the right manner and whether the right number of people have voted, we need to look and understand the concept of voting rights. The general principle is that apart from your preference shareholders, they're a separate case. I've spoken about them enough. The general principle is that every shareholder, every member of the company may vote at meetings. In a company with a share value, a share capital, every member's voting rights corresponds with the size of their shareholding. Every member has a vote in respect of each share held. In a company limited by guarantee, every member has one vote. So there we don't, because there's no shares, so one doesn't have more shares than the other. So limited by guarantee, every one member, one vote. In a company with a share capital, the voting rights, the relevant voting rights, relative voting rights, will correspond with the size of the individual shareholder's share capital. We've learned with regard to this aspect, every member has a vote in respect of each share held. Companies Act then proceeds to state that the total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his or her shares bears to the nominal value of all the shares issued by the company. Just want to quickly check my next slide. Okay, there is an example. I'm going to work through an example to clarify that shortly. So if the company has issued par value shares, the total votes of an individual shareholder must bear the same proportion to the total votes in the company as the nominal value of his or her nominal value, par value of his or her shares bears to the nominal value of all the shares issued by the company. No par value shares, one share, one vote. So if you have 10 no par value shares, you have 10 votes. If you have 5 no par value shares, you have 5 votes. One share, one vote. Okay, and then just the reminder there once again about preference shares, no general voting right, blah, 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 blah. Let's look at the calculation of voting rights as it pertains to par value shares. So the provision says the total votes of a member must bear the same proportion to the total votes in the company as the nominal value bears to the nominal value of all shares issued by the company. As the nominal value of his or her shares bears to the nominal value of all shares issued by the company. So the first thing you need to calculate is the nominal value of all shares issued by the company. So let's say, for example, that the issued share capital, and remember it's issued share capital, it's not authorized share capital. Sometimes I'll randomly throw into a question, tell you what the authorized share capital is. That just serves the purpose to confuse you. We're working with issued share capital. You need to calculate the nominal value of the issued share capital. That would be your first step. I will give you the information of what the issued share capital is. This is a very simple example. Let's say the issued share capital of the company company has issued 400 Class A shares with a par value of $2 each. To calculate the value of the total issued share capital, you simply do the maths. 400 shares that are with a nominal value of 200 each, that gives you 400 times $2, that gives you $800. So the total issued share capital of the company is worth $800. The total, obviously, is 100%. A total is always 100%. And then you look at the Then you look at the individual shareholders. Let's say the facts in the case study tell you that Biri owns 100 Class A shares. What is the total value of Biri's shares? 100 times $2 gives you $200. Now, the Act says that the total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his or her shares bears to the nominal value of all shares issued by the company. So we need to find out now what proportion of the nominal value of the total shares does the individual shareholder own? What percentage of the total shareholding does he own? So you calculate the percentage. Simple maths, you will have your calculator with you. He's got 200 of a total of 800. Calculate the percentage, that's 25%. The total value of his voting equals the percentage that he owns of the total value of the issued shares. So if the total of his shares is 25% of the total value, he has 25% of the votes in the company. As simple as that. Are you with me?
Yes, ma'am.
Great. I try to keep my case studies relatively simple, not to complicate them too much. But once you've grasped, like that whole phrase that I've read a couple of times now, might sound complicated, might sound confusing. But the moment you've grasped that the value, the percentage that this individual has of the total value is equals his percentage of the voting rights, it becomes relatively simple to calculate. Obviously, if there's more than one shareholder, you will just do this whole sum over and over and over again. I will provide you there, or in fact, it is already on e-learning, some sample questions where you can also see how I've calculated this. When you answer, listen to me carefully. When you answer a case study, you are allocated marks for your calculations. For this is 1, 2, 3, 4, 5, potentially 6 marks. Your calculations form part of your motivation to get to the answer. So don't do your calculations on a little scrap piece of paper. Don't, when you start doing a question based on Unit 8, first sit down and start from the top of the page and calculate every random thing you can think of to calculate, and then start answering your questions. Your calculations form part of your answer. I do not know why students find this hard to remember. You are all accounting students. Annual financial statements have a particular format. You start with assets, then you have liabilities, and then at the end you get profit. You don't calculate the profit before you list the assets. So your calculations form part of your question. Okay, then the manner of voting. How does voting take place at meetings? Votings can take place in one of two manners. Either voting by hand, where you literally put up your hand. It's as simple as that. So all those that vote in favor, put up your hand. But then if voting takes place by hand, this whole issue of voting rights and how many shares you have, etc., becomes irrelevant, because every person can only put up one hand. Voting by hand, voting rights are not taken into consideration. It's one person, one vote. And generally, usually, no proxies are included when voting takes place by hand. Voting for a special resolution, however, is different. Remember that. We're going to get to special resolutions. If voting takes place by poll, and please remember it's P-O-L-L, not P-O-L-E. This isn't a thing that's been planted into the ground. Voting by poll, so voting on paper, is where the voting rights of each individual shareholder is taken into consideration. So if, yes, Evelina, your hand is up.
No, ma'am, sorry, I didn't have a question.
Okay. Anyway, I was going to use you as an example now. That's why I went onto my class screen, just to get the names. Let's say Evelina, Julius, and Hilma are the three shareholders in the company. But Evelina owns 50% of the shares. Julius owns 30 and Hilma owns 20. Evelina will have 50% of the voting rights. If they vote by hand, it's 1, 2, 3. One person, one vote. If, however, voting takes place by way of poll, Evelina will have 50% of the voting rights, which means depending on the type of resolution, but chances are that she will always be able to sway the decision in her direction. Not always, but mostly. Sometimes voting took place by hand and the shareholders are not happy with the outcome. In that case, the Companies Act provides that shareholders may demand a poll. So after voting took place by hand and they're not happy, they may say, no, we don't accept this. We demand that voting takes place by poll so that each of us can exercise our full voting rights. Requirements for demand for a poll: at least 5 members having the right to vote, or a member or members combined that have at least 10% of the voting rights in the company, or a member or members entitled to vote at the meeting who have at least 10% of the issued share capital of the company. Don't need to remember these details. Is in the handout. I very, very rarely assess this. I can't actually think now of a question where I expected you to tell me whether they may demand a poll or not. What I do often do is I will say voting takes place by hand, and then another separate question, would it benefit whatever shareholders to demand a poll? Which means you have to calculate the outcome of the voting if voting took place by hand, calculate the outcome of the voting if it took place by poll, and see would it make a difference to whether the resolution has been adopted or not.
Miss?
Yes.
I'm sorry, I think there are two Evelinas in the class. I was struggling with my mic a bit. I wanted to ask, you mentioned that for the voting rights, when calculating, you said that we use share capital. What must we ignore? What did you mention that we should ignore?
Did I say you must ignore anything?
You said that.
Yeah. Oh, yes. I remember now, Evelina. You work with issued share capital, not with authorized share capital.
All right, thank you.
Sometimes if I want to be mean, I will tell you as part of the case study that the authorized share capital is blah, 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 blah. And then I'll say the issued share capital is blah, 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 blah. Just ignore whatever information I give you about the authorized share capital. It's not relevant. I just throw it in there to confuse you. But I've stopped doing that. I don't set out to confuse my students anymore. You work with issued share capital. Ignore authorized share capital. It's just those shares that have actually been issued. Are you with me?
Yes, thank you, Miss.
Okay, great. So demand for a poll is not that important. Let's move on. Then we get two types of resolutions. You get ordinary resolutions and you get special resolutions. An ordinary resolution, in order to validly adopt an ordinary resolution, you require a simple majority. A simple majority is just one more than 50%. Not 51%, one more than 50%. 50% plus one. That is a simple majority. A special resolution. Typo. A special resolution, we are going to, in the next slide, we get to special resolutions. A special resolution requires a special majority, namely 75% of the shareholders present and voting. Important here, if you refer to the 75%, we talk about members present and voting. We do not talk about the total shareholding in the company. When it comes to checking, did enough people vote? Only the votes of the people that are there or have given proxies are counted. If you didn't bother to pitch up for the meeting, you cannot expect your vote or your voice to be heard. If you don't come to the meetings, if you don't participate, sit down and forever hold your peace. These majorities of the members present at the meeting, not present in the company or not in the company at all as a total. Okay.
Sorry, ma'am.
resolutions. 207 of the Companies Act. This is in your handout as well. Yes. Yes.
Sorry, ma'am.
Proceed.
Your network just tripped. I didn't get you well.
Sorry,
Ma'am, your network has started breaking.
Oh, for goodness sake. Can you not hear me?
We cannot hear you, ma'am. It's breaking.
For goodness sake. Okay. It's my laptop. Can you hear me or not?
We can hear you.
I can hear you now.
Okay, can you hear me now?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am. We can hear you now.
So okay, fine. So let's carry on then with special resolutions. We're
sorry,
nearly
ma'am.
done with the class. Yes.
Sorry, ma'am. On the previous slide, I didn't get you well. On the special resolution where you said it's 75%, are the proxies also included in the
I'm going to get to that
75%?
in the next slide. I'm going to get to
all
that in the next slide. So yeah,
all
yeah,
right,
we're
ma'am.
literally looking at special resolutions now. So for special resolutions, we've already seen that the notice that is required is 21 clear days before the meeting. The notice must be in writing and it must state the purpose of the meeting, that the intention of the meeting is to propose a special resolution and all the necessary details. Then for a quorum, if it's a meeting, we've seen here that your quorum requirements, where was that slide? For an ordinary meeting, if it's not a special resolution, your quorum requirements are either 3 people entitled to vote or 2 people entitled to vote present in person or by proxy. If it's a special resolution, the requirements differ. For the meeting to be properly constituted, if it's a special resolution, the Companies Act states that at least 1/4 of the total votes of all members entitled to vote at the meeting must be present in person or by proxy. So to check if there's a quorum, you first need to check what is the value, the par value of all the shares issued. Then you check the par value, the voting rights of every individual that I've told you is at this meeting. And you add them together and you do the maths. Is this 1/4 of the total or not? If it's less than 1/4, there is no quorum, the meeting cannot proceed. So for the meeting to be properly constituted, quorum requirement, at least 1/4 of the total votes of all members who are entitled to vote at the meeting must be present in person or by proxy. Once again, entitled to vote, so you need to decide, are you going to be including your preference shareholders or not? Then when it comes to voting, if voting takes place by
The network has
Your
started,
network,
ma'am.
hands, when it comes to voting, what I've said in the previous slide, now you work
Ma'am, your
only with
network is
those
bad.
that are at the
Ma'am,
meeting,
the network is too
not
bad.
in the company, but at the meeting.
The network, ma'am.
Is my network cutting out again?
Yes, ma'am.
Okay. I'm going to end the class. I'm going to end the class because yes, no, I'm end the class. To me. Yeah, don't shout at me. You're being very, very rude.